Good morning.
Good morning. Your client's in the hallway. I'll bring him in so we can go on the record.
Thank you.
Go to the first row.
Yes, ma'am.
Comer. Just Aaron Comer. Comer and then Hunt. Okay, we are on the record. This is the people of the state of Michigan versus Aaron Comer, 2357165. Mr. Comer is charged with count 1, weapons, firearms, discharge from vehicle. Count 2, weapons carrying concealed. Count 3, assault with a dangerous weapon, felonious assault, as well as counts 4 and 5, assault with a dangerous weapon, felonious assault. Count 6, 7, 8, and 9, weapons, felony firearm, set for a probable cause conference today. Appearances?
Alexander Kirker on behalf of the people, P86282.
And good morning, Your Honor. Respectfully, Jihad Gaddafi, 82492, appearing on behalf of Mr. Aaron Comer.
And Mr. Comer is in person today. Mr. Comer, please state your full name for the record, please.
Eric Ramon Comer.
Thank you. Good morning. Okay, Attorney Gaddafi, you have discovery.
I do, Your Honor. I would like to set this matter for preliminary exam, but I'd also like to place something additional on the record with the court's permission after the exam date, Your Honor.
All right, let's see. You have June 21st available at 1:30.
I do, Your Honor.
Okay, so June 21st at 1:30 for preliminary exam. Mr. Comer, you're already here in person, so you know how to get here, how it works, and you're on time. So your exam is set for June 21st at 1:30 p.m. right back here in course, okay?
Thank you. I don't know what to say.
You're fine.
And Your Honor, for the,
Okay. Attorney Gaddafi, go
and Your
ahead.
Honor, for the record, this is our third set preliminary exam for Mr. Comer. This matter was before the Honorable Giles previously on 2 other exam dates. On both those exam dates, the people were not able to produce a witness. So this is our third preliminary exam. And I just want to stress on the record that if the people cannot produce a witness again, we can't just keep bringing Mr. Comer to court.
Okay, I don't have any of that history in the register of actions. So I will just make sure you remind me on the day of the exam. And I'm sure if the witness isn't here, then it will likely be dismissed, unless there's some reason for good cause, but it's been noted on the record.
The 21st.
Okay. You're all
Thank you,
set.
Judge.
Have a good day.
Okay, do I need like paper or something?
Do you want your day on a piece of paper?
I would love that. I'm sorry, I'm scared.
Don't worry about it.
No, you
I
can do
just
five.
want me to turn my back or something.
Hey, well, I'll stand my seat. I'll bring the table down.
Thank you so very much. I'm so sorry, guys.
No problem.
Thank you for having me.
You're welcome. Anthony Hunt?
Ready on Anthony Hunt, Yana.
Okay, this is case 2357203, the people of the state of Michigan versus Anthony Hunt. Mr. Hunt is charged with 1 count of stolen property, receiving and concealing a motor vehicle, set for a probable cause conference today. Appearances?
Alexander Kirker on behalf of the people, P86282.
And good morning, Your Honor. Attorney Kevin Basant, P71061, on behalf of Mr. Anthony Hunt, who's also present by Zoom video.
Mr. Hunt, can you state your full name for the record, please?
Anthony Hunt.
Okay, Attorney Bassan, do you have discovery?
I do have discovery, Judge. I just received, though, the digital discovery yesterday, so I did want time to kind of review that with my client. Is it possible, Judge, to set this for a new PCC?
I want to put an exam in on the docket. How much time do you need to review it?
No more than a week, Judge.
Okay. How about the 22nd? Is that enough time for, wait, is that enough time for an exam? Or you saying that you need a week for a PCC?
You mean, so you wanted to set an exam on the 22nd?
Yeah, you can have a PCC in between if you want.
Is it possible to do a preliminary exam that following week, Judge?
I'll be in training all that week.
The only thing, because I'm in trial all next week, Judge, that's my only issue with that. But I have no problem, I guess, setting it for an exam.
I didn't hear the last part. What did you say?
I said I am in trial all next week. And so,
Okay, so luckily for you, we have to go to July for an exam day.
well, what day works for you, Yana?
Let's see, July, can you do July 5th?
You know what, that'll work, Judge.
Okay. What time?
Can we do 9 a.m.?
That would be wonderful. Do you
And
want
that,
a schedule in between there?
no, we can just go forward with the exam, Judge, that's fine.
Okay,
But I would like to address one issue of bond, if I may, Judge.
okay, let me just make sure Mr. Hunt understands he needs to be in person. Mr. Hunt, can you hear me?
Yeah, I can hear you.
Okay, your exam has been set for July 5th at 9:00 a.m. in person at 36th District Court. That means you have to show up to 36th District Court on time for your exam. Do you understand that?
Yes, I understand.
Okay, Attorney Bassan?
And so, Judge, at the arraignment, the magistrate did issue a tether for Mr. Hunt. And the reason being is based upon the facts of the case, because it was alleged that there was a fleeting and eluding in this particular matter. But I would like the court to know, Judge, that Mr. Hunt, he's 18 years old. He's a student at Lane College. This happened allegedly while he was back home for the summer. But he's set to go back to Lane College literally in the next 2 weeks. And so I was going to ask if that tether condition could be removed. He's 18. He has no criminal history whatsoever. He'll be under the supervision of his mother. His mother is actually moving back to Tennessee as well, because they plan to just reside there altogether. And so I would just ask if the tether could be removed, and if he can have permission to just travel back and forth to Detroit while this case is resolved, Judge. But no criminal history whatsoever for the young man.
Anything for the people?
People leave it to the discretion of the court.
So what's the reason for wanting the tether removed? I'll allow him to travel back and forth, but just because of the inconvenience of the tether, or?
So the purpose of the tether removal, Judge, is that it's not only for the travel purposes, but it's for he's going to be around other students. He's going to be in class. He's starting his sophomore year at college, Judge, and I just think it sets a bad image for him at the school. And I think that this case will be resolved one way or the other successfully. And so I'm just asking if that tether condition could be removed. He's not a flight risk or a safety risk, but the magistrate specifically stated that she put it on just between now and the PCC to make sure that there were no issues. And there's been no issues since he's been untethered.
Okay, where is he going to school this summer?
He's going back to Lane College. Lane University. Is that correct, Mr. Hunt?
No, Lane College.
I'm sorry, Lane College.
Okay. All right, I will have the tether removed. Mr. Hunt?
Yes.
I want to be very clear. If you miss your court date and you don't show up, I will issue a caveat. And that means I will issue a warrant for your arrest, and it will be a cash amount, okay?
Okay.
You understand?
Yeah, I understand.
So I'm going to lift the tether and allow you to go back and forth to school, but you need to be here for your exam date on July 5th at 9:00.
No problem.
All right,
Thank
anything
you
else?
very much, Yana. And would the order be emailed to me or just given straight to the county jail?
Well,
Okay, thank you very much, Judge. I appreciate it.
you're welcome. What state is he going to school in?
Tennessee.
All right, I got it. You're all set, Mr. Hart.
Thank you.
Okay, Attorney Kadar, you got a problem with the date I gave.
Yes, Your Honor.
Wonder why it was so wide open, it's because it's blocked on the docket. Okay,
Yes, no,
can you do 11:59 on that day?
I can, Your Honor.
Okay, that's the last possible time we can schedule for that day, so we'll change it to 11:59.
Yes, Your Honor.
And your client, can you make sure to let him know, because we just gave him notice that it was 1:30.
No, Judge, we did.
I sure
Oh,
will,
fine.
Your Honor.
Okay, all right, so 11:59 on June 21st, thank you.
Thank you, Judge.
Have a good one. Okay, Thursday, who is your client?
Good morning, Your Honor. My client is Antonio Edwards.
Okay. Give me a moment on your matter.
Certainly.
Okay, 1 second. Is there anyone present on Mr. Alvarado? Attorney Cohen, who are you here for?
Good morning, Your Honor. You got to take the elevator. I'm sorry. I'm here for Keith Lindsay.
Okay, he's checked in. And Attorney Baird, I have you checked in.
Good, Judge. Oh, I'm sorry. Judge, mine is just a set for a preliminary exam and he's present.
Okay, yep, I have him checked in. So Keith Lindsay and then Jermaine Bayfield. Okay, the people of the state of Michigan versus Keith Lindsay, 2357160. Mr. Lindsay is charged with count 1, weapons, felony firearm, third offense notice, count 2, weapons carrying concealed, count 3, weapons, firearms, possession by a felon, count 4, weapons, ammunition, possession by a felon with the habitual offender, fourth offense notice set for a probable cause conference.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Neighborhood Defender Service by Jonathan Cohen, P86151, appearing by Zoom with Mr. Keith Lindsay, who's also present out of custody by Zoom. Mr. Lindsay, can you please state your name?
Keith Terrence Lindsay, Jr.
Attorney Cohen, do you have discovery?
Paper only. I've just emailed this morning a standard motion and proposed order for discovery. I also emailed Mr. Solwaki and Mr. Kirker last night just requesting digital. I think there's at least body worn camera, possibly dash cam that I'm requesting.
Mr. Kirker?
I have that it was sent over on the 12th, but I can always resend it directly.
Well, it's in our system. I'm sorry.
No, go ahead. I heard you.
Yeah, I was just saying it's possible if it was just sent yesterday, it might not have been uploaded yet in our system, but
Okay, and I have your order outside of the and send it back.
thank you.
We need a date. Let's see here.
Date, and I also wanted to address the tether if I could, whenever the court is ready.
Okay, give me 1 moment. Can you do the 22nd in the morning, 10:30, 11?
Yes, I could do the 22nd at 11 if that works for everybody else.
That works for the court. Okay, Mr. Lindsay, your exam has been set for June 22nd at 11 a.m. in person at 36th District Court. Do you understand that?
Yes, Your Honor.
Okay, so as far as the tether, Attorney Cohen?
Thank you, Your Honor. We're asking the court to consider removing the tether condition, or in the alternative, just having it be a GPS tether with no house arrest and no curfew. Mr. Lindsay does not to my knowledge, have a significant criminal record involving violence or anything that would cause a significant concern as it relates to dignity or the safety of the community. This offense, as the court is aware, is a status offense. It's based on Mr. Lindsay's prior convictions for felony firearm, not based on any particular danger that he poses to the community. Also, I'm not aware of any capious history. If the people are, I'm sure they'll share it, but Mr. Lindsay is here. He's clearly showing that he's taking responsibility for this, and that he's going to make his court appearances. So I don't believe that he's a flight risk. He's a longtime resident of the Detroit area. He has a total of 9 children in the area, including a 4-month-old that lives with him. He has a vehicle. He got his GED after in 2021. He started his own home healthcare business, which he has been running. He has several employees, and he has several houses that he goes to provide home healthcare services for people. He's been doing his best to scramble and get people to cover for him, but these are elderly and disabled people who rely on him on a daily basis to provide home healthcare services. And then he also generally covers night shift for employees that have to call off. So he has some clients that require 24-hour care, and unfortunately, sometimes his employees are not able to make their night shift appearances. And typically, he would go out in the middle of the night and cover these shifts. And he's been unable to do that while on house arrest and tether. So he's also very involved in his community. He has a pet pig that he takes out to parks and community functions and schools, just to provide sort of some entertainment and something pleasant for kids. So again, I don't think he's a danger in this case to anybody in the community, nor is he a flight risk. Thank you.
Do you think for the people?
People would ask that bond remain the same, given that this is a 4th offense notice.
I will not remove the tether, but I will lift the house arrest and curfew to allow him to work and provide for his family.
Thank you very much, Your Honor. Will the court be sending something directly to Tether, or should I, if I get a copy, I'm happy to fax it to Tether as well?
We'll send it over and we'll send you a copy as well.
Very good. Thank you very much, Your Honor.
Welcome.
All right, Mr. Lindsay, you're all set.
Mr. Lindsay,
Yes, Your Honor.
just to be clear, I lifted your house arrest and I lifted your curfew. You're still on tether. Everything else, all the rest of the conditions for your bond remain the same. Of course, no possession of firearms or any ammunition. You understand that?
Yes, Your Honor.
Okay. And you are to be in person for your exam on the 22nd at 11 a.m. Okay?
Yes, Your Honor.
Okay, Mr. Longo, start with that. Okay, let's handle Mayfield. I'm sorry, not Mayfield, Mayfield. This is case 2357221, the people of the state of Michigan versus Jamari Mayfield, charged with count 1, weapons carrying concealed, count 2, police officer assaulting, resisting, and obstructing, set for a probable cause conference today. Appearances.
Alexander Kirker, on behalf of the P86282.
Good morning, Judge. Melita Baird on behalf of Jamari, I think it's Mari Field. We're requesting to set this matter for exam, P43238.
Okay, Mr. Mayfield, can you say your name, please?
Jamari Mayfield.
Okay. Attorney Garrett, does 22nd work for you at either 10 or 11?
Let's see, the 22nd, 11 is the latest you can do it?
We can do 11:30.
Okay, 11:30 on 22nd is good. Thank you, Judge.
Okay, Mr. Mayfield, your exam has been set for June 22nd at 11:30 a.m. in person at 36th District Court. Do you understand?
Yes, Your Honor.
Judge, he just wanted to address his tether. He said he's having a hard time getting in contact with the tether agent, and he's under house arrest. And Mr. Minifield does work It's my understanding he doesn't have a criminal record. He's not currently on probation or parole. So we would ask for some adjustments with the tether, especially the house arrest part.
Anything from the people?
We believe it's the discretion of the court.
I'll take the house arrest off, but the tether stays on.
All right. Okay. Thank you, Judge.
And I'll send it over to the tether unit and you'll have a copy also emailed to you.
All right. Did you hear that, Mr. Minifield?
Yes, ma'am.
All right. Judge, have a good day. Thank you.
You as well. You're all set, Mr. Manning, so you can log off.
All right.
Attorney O, who is your client?
Morning, Judge. I have two,
Okay, who are they?
Michael Pierce and David Hardrick.
Okay, let's handle, I guess I should ask Attorney Mencken, are you asking to waive your client's presence today?
Yes, Your Honor.
Okay, let me call your case and then I'll call Attorney O's case. Leonard Henderson. This is case 215737, the people of the state of Michigan versus Leonard Henderson. Mr. Henderson is charged with count 1, police officer fleeing third-degree vehicle code. And same for count 2, and count 3, police officer assaulting, resisting, and obstructing set for a probable cause conference today. Appearances.
Alexander Kirker on behalf of the people, P86282.
And good morning, Your Honor. Steve Mencken, P31562, appearing on behalf of Leonard Henderson.
And your client is not present today. Are you asking to waive his presence?
Yes, Your Honor.
Okay. You have discovery?
I do have the written. I may have the other discovery, but my hard drive filled up. I had to delete everything, and I think I have a download of something. It may be this file.
Okay.
But if I don't, I would just ask that it be sent if it hasn't.
Yeah, it was sent yesterday afternoon.
Okay, then I'm sure I have it. I just couldn't open it yesterday, but I'll open it today.
Okay. No, I'm sorry. Okay, you're looking for an exam date?
I guess that's all we can do. Hopefully I can get a hold of them somehow.
Okay. You do the 22nd at 10 o'clock?
Let me take a look. Unfortunately, I'm in a, it's by Zoom, but it's a trial at 10 o'clock in juvenile court.
Okay. What about the next day? Do you think you'll be done, or are you going into the next week?
These trials, they just go half days. The next day, what time would you want it?
Either 9 o'clock or 1:30.
Can't do 1:30. Let's put it on. Let's do 9 o'clock.
Okay. And if you have some issue with discovery, just email the prosecutor. If you have his email address, I can send it to you.
I don't. If you can put it in the chat.
I will do that.
Okay, so you said June 23rd at 9 o'clock.
Correct.
Okay, I got that date.
Perfect.
In person, yes.
Yes.
Okay. Thank you, Your Honor.
You're welcome. I just sent the email as well.
Okay, I'm going to write that down before I leave, and have a good day.
You as well. Thank you.
Yeah.
Okay, Attorney O.
Morning, Judge.
Good morning. And a Michael Pierce first. Okay, case 2357163, the people of the state of Michigan versus Michael Pierce. Mr. Pierce is charged with count 1, controlled substance delivery, manufacture methamphetamine. Count 2, controlled substance delivery, manufacture cocaine, heroin, or another narcotic less than 50 grams. Count 3, controlled substance delivery, manufacture cocaine, heroin, or another narcotic less than 50 grams. With the habitual offender fourth offense notice set for a probable cause conference today. Appearances.
Alexander Kirker on behalf of the people, P 86282.
Morning, Judge. Neighborhood Defender Service by Gleno, P 83424, appearing on behalf of Mr. Pierce, who's present via Zoom. Mr. Pierce, please state your name. You're on mute, Mr. Pierce. You got to tap your screen and click the red microphone.
Michael Pierce.
Thank you. Attorney, do you have discovery?
Yes, Judge, we have both paper and digital discovery requesting an in-person preliminary examination date.
Okay, can you do the 22nd at 10 o'clock?
1 second, Judge. Judge, I have a 10:30 exam.
At 36?
At 36, Judge.
How about
That's
9:30?
That works for the fence.
Okay. And if for some reason, we have a 9 o'clock schedule, just remind me that you have a 10:30, if for some reason we're moving or behind.
Yes, Judge. And Judge, may we address bond at the appropriate time?
Sure, let me just let Mr. Pierce know of his exam date. Mr. Pierce, your exam is set for June 23rd. I'm sorry, the 22nd, right?
Yes, Judge, the 22nd.
Okay, I wrote 23rd. June 22nd at 9:30 a.m. in person at 36th District Court. You understand that date, Mr. Pierce?
Yes, Your Honor, I do.
Okay, that you're to be in person. You understand that as well?
Yes, Your Honor, I do.
Okay, and Attorney O, go ahead and address the bond.
Thank you, Judge. Mr. Pierce is out on a personal bond with the GPS tether, but he had informed me that he actually resides in Franklin, Pennsylvania. His fiance is there and his 2 children are there as well. Mr. just comes into Michigan for work. Mr. Pierce has no objection to keeping the tether on him. He just wants the court's permission to reside with his family. It's about a 4-hour drive.
Okay, Mr. Becker.
We believe it's a discretion of the court.
I can see that he has ties to Pennsylvania, based off of the information and what I have in the file. So I will allow him to go to and from Pennsylvania to be with his family. Mr. Pierce, but you are not to miss your court date. You understand that?
Yes, ma'am, I wouldn't.
Okay, so I'm going to send an order over allowing you to travel to Pennsylvania and back.
Thank you, Your Honor.
You're welcome. Anything else?
No, Judge, thank you.
Okay, go have a good day. Attorney Rob.
And Judge, I also have David Hardrick.
I forgot that fast. Okay.
And Judge, may I ask if Mr. Hardrick is in the waiting room? Our office has not had contact with him.
No, he's not in the waiting room. There's nobody in the waiting room other than an attorney. Okay. Give me one moment. I have to file the- Which one do you need, Judge Hardwick? I have it right. Oh. Okay, this is case 2357177, the people of the state of Michigan versus David Terrence Hardwick. Mr. Hardwick is charged with one count of robbery unarmed with a habitual offender fourth offense notice set for a probable cause conference today. Appearances.
Alexander Kirker on behalf of the people, P 86282.
Good morning again, Judge Gleno with NDSP 83424, appearing on behalf of Mr. Hardrick, who is not present. We're asking the court to waive his presence for today's hearing.
Wait, Mr. President. You have discovery on this case?
Judge, we have both paper and digital discovery on this case as well.
Okay.
Judge, our request would be to adjourn the PCC to the same date on June 22nd to allow our office time to locate Mr. Hardrick.
Because we have a really messed up schedule these last 2 weeks of June, I'm going to allow that. So I will adjourn it to 22nd at 8:30. And hopefully you can find a client by then.
Judge.
You're welcome. Anything else?
No, Judge.
All right, have a good rest of your week.
Thank you, Judge.
Mr. Jonathan and Mr. Alvarado, we're just waiting for your lawyers.
Good morning, Your Honor.
Good morning, how are you?
Good. May I request that the Paul Rice matters be put over for tomorrow? I could bring in the reports. The doctor did finish them. I do have an in-person matter. The Nance hearing, pre-exam hearing tomorrow. Is that okay with the court?
Yes, it is.
Thank you.
You're welcome, 9 o'clock, see you then.
Thank you, Your Honor. I'll see you tomorrow.
Okay. You're welcome. I had, somebody, wasn't on that. Mr. Johnson, your attorney is here. I'm gonna call your case. This is 2162386, the people of the state of Michigan versus Donald Johnson. Mr. Johnson is charged with count 1, weapons, firearms, possession by a felon. Count 2 and 3, assault with a dangerous weapon, felonious assault. Count 4 and 5, police officer assaulting, resisting, and obstructing. Count 6, 7, 8, 9, 10, weapons, felony, firearm with provincial offender. Third is notice set for a competency hearing again. Appearances.
Alexander Kirker on behalf of the people, P 86282.
Alicia Mariano, P 69003, on behalf of Mr. Johnson, who appears by Zoom.
Mr. Johnson, unmute your device, please, and state your name. Mr. Donald Johnson. Unmute your device, I can't hear you.
Oh, can you hear me now?
I can. State your name for the record, please.
Donald E. Johnson.
Thank you, good morning.
Your Honor, this is the date time that was set for a competency hearing. We referred him to the forensic center, I think about 90 days ago, and they have still not gotten around to completing their evaluation. And the only communication I have received from them is just a form letter stating that they are backed up in their evaluations and they need more time. So I know this case has been on this docket for a very, very long time, but I just don't see how we can move forward without the evaluation. So we could put it out another 60 days or so.
And I was hopeful, I did do 60 days. The last time we were 60. So let's try another 60. Let's get a date. So today.
Well, August 29.
That's fine. Okay, Mr. Johnson, I still have a report from the forensic center.
Yeah.
Your attorney, as she stated, they provided a note to her saying that they're backed up with providing reports. So I am going to adjourn this matter to August 29th at 9:00 a.m. Log right back on Zoom as you did this morning, and hopefully they will have a report by then.
Yes, ma'am.
Okay, anything else from either party?
No, Your Honor, thank you.
Thank you. Have a good day, Mr. Johnson. You can log off.
You too.
Attorney Sanders Rush, good morning.
Good morning, Judge.
How are you?
I apologize. I was in other courtrooms.
That's fine. Do you want to speak to Mr. Alvarado before we go on the record?
Yes, that'd be great. Thank you.
Okay. Mr. Alvarado, go ahead and mute your device or have someone unmute your device so that you can speak to your attorney in private. Jacob Mathis. Ready,
Judge. Yes, I'm ready on Ulysses Alvarado, yes.
Okay, this is case 1759465, the people of the state of Michigan versus Ulysses Alvarado. Mr. Alvarado is charged with count 1, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. Count 2, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. Count 3, controlled substance, delivery, manufacture, marijuana. Set for a probable cause conference today. Appearances.
Alexander Kirker on behalf of the people, P 86282.
Good morning, Your Honor. Neighborhood Defender Service by Summers Brush, P number 85828, appearing on behalf of Ulysses Alvarado, who's present via Zoom today. However, I don't think he's left the breakout room, and he was, oh, there he is. He was having a hard time unmuting, so I'm happy to waive his presence today.
I believe he is present with the device unmuted. Let's see. Mr. Alvarado, can you state your name?
Okay.
The device is unmuted, but there's no video.
Yes, I see that.
It's a couple seconds because he has sitting here ready to go. I do want him to hear what's going on.
Just.
Okay. I don't know what's going on.
I'm not sure either, Judge, but I was able to communicate with him via writing things down, and he did indicate that he would like to appear on Zoom for his preliminary examination instead of being transported from the Michigan Department of Corrections. And I also want to note for the record that we have not received any paper nor digital discovery in this case, so I would be requesting that from the people today.
This is a slightly older case. We're still in the process of finding the file. It's not too old, so I think we should be able to find it. And once we find it, we can then send over discovery.
Okay. So I will set an exam date. You have June 30th at 9 o'clock available.
I'm going to be out of town that day. I apologize.
Well, since it's on Zoom, I don't have to wait 2 weeks to have them read it out. Can you do anything?
I can do the 26th, Monday the 26th. I can also do the Wednesday the 28th.
That whole week will be a trade.
Oh, okay. I can also do next week.
What day can you do next week?
I can do the I can do Wednesday the 21st.
Okay. Can you do 1:30?
Yes, Judge, I can do that.
Okay. Are you gonna be able to communicate? Well, they logged off anyway, so you're gonna have to let your client know of his exam
Yes.
day.
Yes, I will find a way to connect with him via the correctional facility where he's located. So,
Thank you.
thank you.
Mr. Alvarado, can you hear us?
Yes, I can.
Okay, you got disconnected. So, the only thing that happened is your lawyer set a date for your preliminary examination.
Okay.
Let me see that date. Clerk just took your file. One moment. Okay, your date will be June 21st at 1:30 PM, and you requested it via Zoom, so you'll be on Zoom.
Okay, you said at what time?
1:30.
1:30. Thank you very much.
You're welcome. Also, on the record, we discussed that no discovery has been provided as of yet. If there's no discovery on the date of your exam, your lawyer will address that to the court, okay?
Okay, thank you.
You're welcome. You're all set. You have a good day.
You too, ma'am.
Okay, Tony Coulter's.
Good morning, Your Honor.
Good morning. You ready for your case to be called?
I am ready. I do not see client Antonio Edwards. He's not there in person, is he?
No, yeah, we checked it all the way. Okay, case 2357197, people of the state of Michigan versus Antonio Edwards, charged with one count of controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams, set for a probable cause, conference today appearances.
Alexander Kruger, on behalf of the people, P86282.
Good morning, Your Honor. Jennifer Colthurst, P52876. I appear on behalf of Mr. Antonio Deshawn Edwards.
Okay, your client is not present at the time. Are you asking to waive his appearance today?
Yes, Your Honor.
You have discovery?
I do have the written discovery and the digital discovery. I am requesting a preliminary examination.
Have you had contact with your client?
No, Your Honor, the number that I was given is not a good number. And I've not received any response from the letter that was mailed out to the Fairport address. So, and I've checked the jail. He's not at the Wayne County Jail. I have no explanation for none.
You have a 502 phone number for him?
I have a 512 number, and I also have a 503 number. I didn't try 502. I just
No,
tried.
that's a 3. It's 503. So you have that number already.
Yes, I tried both numbers, but they're not good numbers.
Okay, I'll send the exam date. Hopefully you can find your client by then. You have June 30th available?
I'm checking, Your Honor. June 30th is what time on June 30th? And that's a good date.
9 o'clock?
9 a.m. is good.
Okay.
Thank you.
You're welcome. Have a good day.
Thank you. Likewise, I wish everyone a good day. Bye-bye.
Attorney Hamilton?
Yes, Judge.
Case 2356357, the people of the state of Michigan versus Jacob Mackless, charged with count 1, weapons carrying concealed, count 2, police officer assaulting, resisting, and obstructing, set for a probable cause, conference today.
Alexander Kruger, on behalf of the people, P86282.
Vanessa Hamilton, P82107, on behalf of Mr. Mackless, who I understand has not appeared in the courtroom. Your Honor, I've also not been able to get in contact with him. I have no explanation for his non-appearance. I would ask that either we get an adjournment, or I'm sorry, I would ask either for a preliminary exam to be set and waive his appearance, or if possible, I guess I also understand if the court needs to capious.
Okay, because he has a capious history, he did not show up for his last exam. I'm going to issue a capious for $1,000 cash. Normally, I would allow for an adjournment. I understand sometimes you can't find your clients, but I believe Mr. Mackless has been made aware of his exam date and very familiar with the process, and did not stay as well. So it'll be $1,000 cash.
Thank you, Your Honor.
You're welcome. You're all set. Have a good day. I didn't ask Mr. Kirk what he thought. Sorry about that.
It's fine, I'm about to give this.
Hi, Your Honor, sorry, I needed to speak. And get some things resolved with our 9 o'clock, defense is here, witnesses are here. we're ready to go on the record, and thank you so much for giving us extra time to try to resolve some things.
Yeah, we don't have an exam till next one, till 10/5, the workout.
But this one won't take long, unfortunately.
1 minute. Okay, this is People State of Michigan versus Demetrius Deontay Johnson. Case 23-55935. Mr. Johnson is charged with count 1, stolen property, receiving and concealing $20,000 or more. Also as defendant number 3. And also, also, is charged with that 1 count set for exam today. Appearances?
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Brian Gagnon, Your Honor, Neighborhood Defender Service, P64220.
Good morning. Okay, today's date set for exam. Are the people ready to proceed?
Your Honor, my apologies. The people are unable to proceed today. We do have our subpoenaed witnesses. However, after speaking at length with them, unfortunately, the people have insufficient evidence at this time to move forward today.
Your Honor, we would motion to dismiss without prejudice, please.
Okay, for insufficient evidence, I will dismiss without prejudice.
Thank you very much.
Okay, I'm filling out the form. It shouldn't take long.
Sounds good.
Mr. Johnson, who's your birthday?
Perfect.
Sir, what's your name? Good morning. Okay, you're muted. I can't hear you.
Antonio Edwards.
Okay, Mr. Edwards, your lawyer checked in already? Have you talked to her?
No, I haven't.
She can't reach you. She said she's been trying to contact you, but she doesn't have a good phone number.
Oh, wow. No, I haven't talked to her.
All right, what's your phone number?
Hold on one second. 586-565-2838.
I'm gonna do you a favor and give your number to your lawyer. She's gonna call you to contact you about your case, okay?
Okay.
Also, I'm gonna give you your exam date. Give me a second. She'll tell you as well, but just since you're here and we're not doing anything right now. Let's see. Your date for your exam is June 30th at 9 a.m. in person at 36th District Court.
Okay.
So, yes, actually, you know what? I'm gonna give you your lawyer's number so you can call her.
Okay.
And if she doesn't answer, leave a voicemail with your phone number.
Okay.
You get it?
What day is it?
On 30th.
June 30th.
Okay, let me know when you're ready to take her number down.
Yeah, I'm ready.
It's 313
313
575
75
5222.
5222. Okay.
Yes.
Which one? Lawyer?
Her name is Colthurst, Jennifer Colthurst, C-O-L and Thirst. Thirst, C-O-L-T-H-I-R-S-T, Colthurst.
Cold thirst. Okay.
Give her a call.
7:30.
All right. It's at you said 7:30?
No, June 30th. June
June
30th.
30th at 9:30.
Yes.
Okay.
So that's 2 weeks from today. No, at 9 o'clock.
9 o'clock.
Yes, June 30th at 9 o'clock in person at 36th District Court.
Okay.
All right. Go ahead, call your lawyer.
Yep. Thank you.
I'm sorry, I said that out loud. I said that out loud.
I can.
Oh, good. Attorney Cole Thursday, good morning again.
Via email. Yeah, she's on it, yeah, especially in exam work. A lot of times it's hard for me to get her attention.
Did you get my email, Attorney Cole Thursday?
Yes, regarding Mr. Edwards.
Yes.
Yeah, thank you so much. I did speak with him, and he wishes to waive the preliminary examination that Your Honor just scheduled for June 30th. He should be on Zoom or zooming in momentarily.
Okay. Antonio. Edwards. It's on the floor. Oh, wow. I know that because I had that for the big. Oh. Something else? Like, we need someone to be ready for their case. Pretty cool about the team. We like, right? Yeah, but it also says. You know, you can tell them to back up, like. Back up, it all happened. I'm just okay. He's connecting his audio. There we go. Okay. Mr. Edwards, can you hear us?
Yeah, I can hear you.
Okay, so I'm going to call your case as soon as the prosecutor comes in the courtroom. They're in the hallway preparing for a matter. As soon as they come in, I will call your matter.
Okay.
Thank you, Your Honor.
He said, we'll be here about 8 to 10 minutes and he's planning on holding and the client will be here too.
Okay.
Okay.
Thank you.
Well,
It's on Antonio Edwards of PC.
Oh,
Okay, we're back on the record on the People versus State of Michigan versus Antonio Edwards, 2357197. Mr. Edwards is charged with one count of controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. Appearances?
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Jennifer Colthurst, P52876. I appear on behalf of Mr. Antonio Edwards. Sir, identify yourself.
Antonio Edwards.
Okay, Attorney Colthurst, is it correct your client wishes to waive his exam today?
Yes, Your Honor, that is correct.
Any objection from the people?
No objection, Your Honor.
Okay, Mr. Edwards, I'm going to ask you some questions. If you can't hear me, or if you don't understand me, let me know, okay?
Yes.
Is it your wish to waive your preliminary exam today?
Yes.
You understand that you have a statutory right to a preliminary exam?
Yeah.
That if you were to demand that exam, the people would have to show with the probable cause standard that that one charge I read off was committed in Detroit and that you probably committed that crime. You understand that?
Yes.
And that by waiving your exam, the people do not have to present any evidence at the probable cause standard. Understood?
Yes.
Do you also understand that you are not giving up your right to trial?
Yes.
Knowing all of that information, you still wish to waive your exam?
Yes.
Did anyone force you or threaten you to waive your exam?
No.
Did anyone promise you anything?
No.
I find your waiver to be freely, understandingly, and voluntarily given. Mr. Edwards, since you are not in custody, your arraignment on the information day will be 2 weeks from today. So that will be June 27th at 9:05 a.m. Frank Murphy Hall of Justice. Attorney Colthurst and Mr. Edwards, since you are both remote, do I have your permission to sign the waiver form?
Yes, Your Honor.
Mr. Edwards,
Yes.
do I have your permission to sign your name on the waiver form since you are not present in the courtroom?
Yes.
Okay. Anything else from either party?
No, Your Honor.
Okay. You all have a good rest of your week.
Thank you, Your Honor. I wish you the same.
Thank you.
Bye-bye.
15 minutes. Turn it into We're on the record as the people of the state of Michigan versus Anthony Eggleston, 2356736. Mr. Eggleston is charged with count 1, weapons, firearms, possession by felon. Count 2, weapons, ammunition, possession by felon. Count 3, weapons carrying concealed. Count 4 and 5, weapons, fighting firearms. The bishop and the third defense notice set for exam. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
Good morning, Your Honor. Vanessa Hamilton, P82107, on behalf of Mr. Eggleston, who joins us in the courtroom to my right. She's here in the
That's me, Anderson.
Okay, good morning.
Good morning.
Everyone ready to move forward?
Yes, Your Honor.
Okay. Any preliminary matters?
Yes, Your Honor. The people have one preliminary matter. People propose exhibit 1. People move to admit pursuant to MCL 766.11B, 1B. People's proposed exhibit 1 is a certified copy of registered actions indicating that the defendant Anthony Eggleston's previous felony conviction of controlled substance, delivery, manufacturing, marijuana with conviction or sentence date of August 29, 2013, from Third Circuit Court here in County. And I have already shown it to defense counsel here.
No objection.
Okay. You'll be admitted as people exhibit number 1. Anything else?
Nothing. Well, I guess we would ask for an order of sequestration for any possible witnesses in this matter.
Okay, if there's anyone on Zoom or YouTube who may be a witness on this case, now's your time to log off as well as in the courtroom. If there's anyone in the courtroom who may testify or be a witness on this case, now's your time to exit the courtroom. Mr. Barrett, you can call your first witness.
Thank you, Your Honor. People call Officer Deshaun Perry.
Clerk, tell the truth, no truth, and nothing but the truth. If you're ready to swear.
Thank you. Sir, do you mind restating your name for the record, please?
Deshaun Perry.
Would you please indicate where you're currently employed, sir?
Detroit Police Department, A Precinct.
And in what capacity, sir?
Ms. Barrett, before you move
Yes.
on, you want your client to say?
Yes, move on to the table.
I'm sorry. In what capacity, sir?
Police officer,
How long have you been a police officer?
3 years.
Officer, were you employed in this capacity on May 3rd, 2023?
Yes.
Were you working by yourself or with a partner that day?
With a partner.
What is your partner's name?
Officer Flannel.
Were you guys in a scout car?
Yes.
Was that scout car semi or fully marked?
Semi-marked.
Could you please tell the court what that entails, semi-marked?
It's all black, Ford Explorer with Detroit Police on both sides.
Both sides?
Yes.
And were you in a full or modified uniform on that day?
Modified.
And what does that entail, sir?
Similar to what I'm wearing now, a black Audi auto carrier with a Detroit Police on the front and back, green pants.
Did your duties as a Detroit police officer take you at or near 16901 West 7 Mile Road in the city of Detroit, County of Wayne?
Yes.
Could you please tell the court what's at this location?
It's a green light location.
Okay. What type of business is this, a green light location?
That's a gas station.
And why were you at or near said location?
I was also at 17256 West 7 Mile. That's Lindsay Liquor. That's a green light location as well.
Could you repeat that address for me, please?
17256 West 7 Mile.
And you indicated that's a liquor store?
Yes.
What were you doing there?
Providing special attention.
Well, at or near either of those locations, did something draw your attention?
Yes, while providing special attention to the liquor store, I observed a vehicle, a gray 2019 Jeep Cherokee, driving to the location of the liquor store, and then immediately exit the liquor store without anyone exiting the vehicle or going inside. When I observed the vehicle driving out of the parking lot, I observed the driver of the vehicle to not wearing a seatbelt.
As a result of your observation, the driver not wearing a seatbelt, what if anything did you do, sir?
At that time, I observed the vehicle going east on 7 Mile. I turned my scout car around, and as I was turning the scout car around, I observed the vehicle fail to signal switch lanes.
Based on these two observations, what did you do?
At that time, I positioned the scout car behind the vehicle and activated my lights to form a traffic stop.
Once you activated your lights, did anything else occur? Did you observe anything else at this time?
Yes, after I activated my lights, I observed the driver of the vehicle reaching towards the radio inside the vehicle. I observed him reaching towards the radio with his right hand. I lost my partner in my observation, and I observed the male reach towards that location all the way until he stopped. And he eventually stopped at a green light location that you mentioned, the 16901 7 Mile.
Once the driver stopped at the 16901 West 7 Mile location, did you approach the vehicle?
Yes, I did. Before I exited the vehicle, I continued to watch the inside of the vehicle, and I observed the driver still reaching towards the radio. It was easy to see inside the vehicle now because the lights from the gas station kind of illuminated the inside of the vehicle. I advised my partner what I observed, and at that time I approached the driver's side of the vehicle with caution because I wasn't sure what he was trying to conceal.
Officer, did you decide or did you approach the vehicle on?
The driver's side?
Did you make contact with the driver?
Yes.
Is that driver of that vehicle in the courtroom today, sir?
Yes.
Could you please indicate where that individual is and identify our clothing?
He's the next defense counsel wearing a green shirt.
Your Honor, may the record reflect the identification of Anthony Anderson. Officer, if you please tell us what transpired, once you made initial contact with the defendant.
Yeah, when I walked into the vehicle, I immediately asked the driver, what was he reaching for? He showed me his phone that was in his right hand. He advised that he's just picking up his phone.
Picking up his phone?
Mm-hmm.
When you say picking up his phone, was there any additional information of where he was picking up his phone?
Yeah, he wasn't like just picking it up from the floorboard, like he picked it up from the ground. But now
He indicated that he was picking up from the floorboard?
Yes. Not at one point that I observed the male reaching towards the ground of the vehicle, the floor of the vehicle. The whole time I observed him making a reaching motion, it was towards the radio.
After the defendant gave you information about picking up his phone from the floorboard, did you inquire about anything else?
Yes, I asked him if he had a valid license.
And what was his response?
He said that he did not.
And just to be clear, at any point after this, was it confirmed whether the defendant actually had a valid license?
It was confirmed that he had a suspended license.
So after the defendant admitted to not having a license and indicating movement on the floor, what did you do with this information, sir?
At that time, I had the occupants of the vehicle step outside the vehicle for a number of reasons, but partially I wasn't sure what the defendant was reaching for, and I feel like he's been untruthful about what he's reaching for. He's also, while I was speaking to him, I observed him to be extremely nervous, which in turn made me nervous. So at that time, I had to exit the vehicle and stand in front of my scout car.
You said you did what after you seemed nervous and you said you seemed extremely nervous and made you nervous. What happened?
I had to make the vehicle.
Sir, you indicated occupants, how many occupants were in the vehicle?
4.
Did all 4 of the occupants exit the vehicle?
Yes.
You indicated, defendant appearing nervous and all the other items that you indicated, made you nervous. What, did you do based on all of this after they exited the vehicle?
I detained the driver and the occupant sitting behind them, handcuffs together. My partner did detain one of the occupants on the outside of the vehicle as well. I did that mainly because it was 4 people inside the vehicle, and I observed the driver making some motions that he was trying to conceal something. At that time, I just didn't feel comfortable leaving I knew I was going to perform a wingspan search of the vehicle, and I didn't feel comfortable leaving my partner with 4 people that just wasn't detained.
So after the occupants were detained, you indicated that your intent was to do a wingspan search. Did you actually personally conduct this wingspan search?
I did.
Can you please detail to the court where you did your search?
Like I said before, I observed the defendant reaching towards the radio of the vehicle. In my experience, that's a common hot spot for contraband, including narcotics, weapons. So I went and I touched the climate control box, which is located directly under the radio, and I observed that it was loose, like it had been tampered with previously. I opened that and I discovered a green and black firearm inside.
You indicate that it was loose.
Yes.
For those of us that are super familiar with the consoles of a 2009 Jeep, is it common to be loose, or how is it normally?
It's not supposed to be open at all. Like I said, with my experience, I've recovered numerous types of contraband from that spot, including weapons. And when I pulled it, like I said, I could tell that it had been opened before.
Was it, you said you pulled it, was it difficult or easy? How was when you say you pulled it?
It was easily opened.
You indicated that you recovered a weapon from that location. Can you tell me, I understand, and again, just for the record, for those of us that are not familiar with 2019 interior with Cherokee, how far was that location from the driver or where you testified you saw it?
It's right in his wingspan, is right where he's reaching towards.
The weapon that you recovered, do you recall, is that exactly the type of weapon that was, sir?
I'm not sure. I think it was a green and black Beretta. Possibly, I would have to look at my report to tell you exactly what it was.
If I showed you your report, sir, would that refresh your memory?
It would.
Your Honor, may I approach? Yes. Officer, review your report. Once you've reviewed your report, you feel that your memory has been refreshed, please let me know. I'll take that back and continue with the question. Has your memory been refreshed, sir?
Yes.
Do you recall what type of weapon that was recovered?
Yes.
What type of weapon was it?
That was a green and black APX Beretta. 9mm.
And do you recall if this weapon was loaded?
Yes, it was.
In the course of your investigation, after you recovered this weapon, did you have an opportunity to learn if this weapon was registered?
No, it appeared that the serial number had been tampered with it. I couldn't read it. I couldn't tell what it was.
In the course of your investigation, Did you have an opportunity to uncover whether the defendant had a CPL?
It was confirmed that he was not a CPL holder.
How was that, at any time did the defendant make any confirmation of this?
Yeah, he realized that he was a felon and could not be in possession of a firearm.
Was the weapon you recovered and its ammunition placed into evidence, sir?
Yes,
And just a couple more questions to clarify. Was the driver the defendant given any other citations?
yes.
What citations was he given?
It's from the ticket for his license and a ticket for felon over seatbelt.
And what, if anything, happened with the defendant's vehicle that he was driving?
It was impounded.
Was it towed from that location?
Yes.
No further questions, thank you, Your Honor.
I have just a couple for verification, you might.
Yes.
Said that you checked if he was a CPL holder.
My partner ran to me.
At the scene,
Yes.
and you said the defendant said he was a felon. Did he also say he could not have a firearm, possess a firearm?
Yes.
When did he do that?
Defendant attempted to claim that the firearm belonged to the passenger, which is the owner of the vehicle. He said several times that he could not, he's a felon, he couldn't take that charge, he couldn't be in possession of a firearm.
Like, any questions based off of what I asked?
No, thank you, Your Honor.
Ross?
So you stated that initially when you were driving, or when you were pulling over, Mr. Eggleston, that he was reaching for the radio?
Yes.
I imagine people reach towards the radio pretty commonly when you pull them over, turn on their music.
It's possible, yes.
Okay, so is that something that you see pretty regularly on the job?
If I do see it, it's quick, so I'm to answer, honestly, no, because if they do it, it's one motion and I don't really pay attention to it.
Okay, so you don't normally pay attention to it. But in this case, you were paying attention to it.
Yes, it's the length of time that he was reaching towards the area. It wasn't like like you mentioned, to turn something off or change it. It was consistent with him reaching for it, like he was trying to conceal something.
Okay, how long would you say that he was reaching for the radio?
From the time I got behind him on 7 Mile, all the way until I was preparing to exit my vehicle inside the gas station, so 30 seconds maybe.
Okay, so you're touching the radio for 30 seconds. And then when you eventually did pull him over, he told you, did you ask him why he was touching the radio or
I asked him what was he reaching for.
Okay, and then he said that he was reaching towards his phone that you dropped off.
Yeah, he said he had his phone, he was picking up his phone.
Okay, and did he have his phone in his hand at that point?
He did.
Okay. But you said that you thought he was untruthful.
Yeah.
Okay, and so because he was untruthful, you decided you wanted to search the vehicle?
Oh, no, so like I said, the length of time that I observed the defendant reaching towards that area, and also because the type of vehicle it was, it's a Chrysler product. Now I'm aware of that compartment specifically, and it just is consistent with somebody trying to conceal something to me.
Okay, so you said you specifically look at Chryslers when you pull them over because you believe people store.
That area, that type of vehicle, and that area is a common hotspot, yes.
So then based off of your understanding of that it was a Chrysler and you had previously found weapons there before, and because you did not feel Mr. Eggleston was being truthful, you pulled him out of the vehicle?
For a number of reasons, yes. He also advised that he wasn't a licensed driver.
Okay, and so you also stated that when you handcuffed the occupants together, so was that after they were pulled out of the vehicle or while they were in the vehicle?
So I had everybody exit the vehicle, and the front seat passenger, the front driver and the occupant behind him, I detained them together because I knew I was gonna do a policeman search of the vehicle. And it was only me and my partner. So I was gonna leave 4 occupants of the vehicle with him while I went to the vehicle. So I detained them together just for officers.
Okay, so they were handcuffed together outside?
Yes.
And at that point, you said that you searched through the vehicle or did a wingspan search?
Immediately I went to the area where I observed the defendant reaching, which is under the radio.
You think you didn't look anywhere else beforehand?
I might have looked somewhere. I might have looked under seat maybe. I'm not sure.
And did you use anything to pry open the radio in that?
My handcuff key.
Okay. So it wasn't so loose that if you just touched it, it fell off. You had to use some force.
Minimum. Yes, I would.
And do you have a body camera on that?
I did.
If I showed it to you, would you recognize it? Recognize the date time?
Yes.
Yeah, either I'm waiting in the waiting room.
Oh, you are?
Oh, you know why? Because I'm on Adams. And so I've got something up on the street. Does that look like the seed that you were at on that day?
Yes.
Okay, so would this likely have been part of your body camera?
Possibly, it likes my body camera.
It's for the record, I would start playing at 2:36, 2 minutes 36 seconds into the clip.
Are you moving to admit? Or
Yes, I would move to admit exhibit 1.
Hey, there'll be a bit of okay, there'll be a bit of defensive.
Okay, and I'll start playing from 2 minutes 36 seconds.
Right there, that red dot. That red dot right there. Hey. You a CPL holder? Oh. You? Oh. Okay, you going to jail then?
Oh, what I'm going to jail for?
CCW, sir.
Bro, I don't got no.
Hold on. Right here?
That's
this one.
not mine, bro.
You going to jail for it?
For the record, I'm stopping at 3 minutes 43 seconds. So you had to go back and forth to the radio at least twice, right?
I did so once I detained everybody from the vehicles. I pulled like I said before, it was loose, but then when I touched it, I felt it was loose. At that time, I went back to the vehicles to make them face my camera because I knew we were out of search. I feel like he knew. I mean, I assumed that he knew where whatever I was looking for was at. I didn't want them to react any type of way, so I could have recovered it the first time, but I decided to make sure that he was facing the camera first.
Okay, is that common practice that you don't want people that you pulled over to see you searching through their vehicle?
When I suspect I'm about to recover something, I just don't want no confrontation at all. I just want to.
So that's why you came around and told them to turn around before you pulled the gun?
Yeah. So when you watch the video, when I went and I pulled the climate control box, I discovered that it was loose, like it had been tampered with. I knew I was gonna open it. So at that time, he was facing me, looking at where I was searching at in the vehicle. That time, I told him to face the camera. before I recovered it.
And why wouldn't you want anyone to see you recover something from the vehicle if you thought they had it?
Well, like I said, I know my body kept recording, so I'm trying to hide. I just don't want no reaction, no confrontation. They could try to run together. They was handcuffed together. They weren't handcuffed behind, they weren't.
But if he knew the gun was there already, wouldn't he have run already? Objection, Your Honor. He was asking the officer to guess what the defendant would do, or he's saying, wouldn't he run if he knew? How do we know if he would run? And he doesn't know.
Are you saying regulation? Is that the
speculation? Yeah. I'll skip the question. So is this something that you normally do when you pull people over?
Yes.
But you believed when you went into the radio that there was already going to be a weapon, right?
Oh, well, some form of contraband, but I was suspecting a weapon, yes.
Because you suspected, because it was a Chrysler, that there might be something hidden in that radio area?
After driving behind the defendant and watching him reach towards that area for a considerable amount of time, I suspected that there's going to be some form of contraband in that area, yes.
And so when you found it was loose, you couldn't remove it with your hand. You went to remove it with the key here.
Honestly, I could have attempted to remove it with my hand, but I knew I could with my handcuff.
And you said as soon as you pulled the gun out of the vehicle, he said it's not my gun.
Immediately, yes, that's what he stated.
And I know we didn't see that on the camera, but he also told you that it was another person's gun in the car, right?
Yeah, as I said before, he made several attempts to make the owner of the vehicle, which was the front seat passenger, take possession of the weapon. Yes.
And as you said, the front seat passenger, it was a female, right?
Correct.
And she was the owner of the vehicle.
Yes.
Okay, so why wasn't she given the vehicle to drive away instead of it being in?
Well, at that time, not only was the defendant unlicensed driver, his license was suspended, I also recovered a firearm from the vehicle, in which no one in the vehicle was a CPL holder. So at that time, the vehicle was part of using the car, basically.
So you ran everyone's name to see if they had a CPL?
We ran the owner of the vehicle, and Mr. Edwards.
And what about the other two people in the car? You didn't?
The one of the occupant sitting behind the driver had a felony warrant, so he went to jail, and I'm not sure if we ran the other occupant of the vehicle.
Okay, so you don't know if anyone had a CPL in the vehicle?
No,
Not confirmed?
I knew the owner of the vehicle didn't have a CPL. I knew the defendant didn't have a CPL.
Okay, but there's two other people in the back that had a CPL.
Excuse me?
The two other people in the back could have had a CPL.
I knew one of them didn't. So it's possible that the last one, it's possible he has CPL, yes.
So I'm still trying to understand, you pulled the car over initially, why?
A simple citation,
Your
yeah.
Honor, asked and answered. He's actually asked it twice. So, and Officer Perry was very forthcoming and direct and indicated why he pulled him over. And in cross, in different ways of asking, has gotten the same answer of why he pulled him over.
Your Honor, I'm trying to specifically see why you pulled him over. I know that there have been questions I've asked, I give multiple different answers, but I want to know specifically what offense.
It's my understanding that he did not have a seatbelt on, that he did not signal once changing lanes, that he observed the defendant reaching in the area right below the radio for 30 seconds while he was pulling the defendant over, and that's why he was pulled over. There's something that I missed.
No, ma'am.
So there was no one else in the car that could drive the car, or did you check that?
Excuse me?
Did you check to see if anyone else had a valid license to drive the car with?
I believe the owner of the vehicle had a valid license. But like I stated before, once I recovered the firearm from the vehicle that was not supposed to be in the vehicle in that area, at least, it was using a crime. At that point, the vehicle was totaled, was impounded.
But you did not confirm that someone in that car didn't have a CPL for that gun.
Well, if that was, I arrested Mr. Everson for carrying a concealed weapon, and because he was in possession of the firearm, and at that point, the vehicle was using a crime, so it didn't matter if somebody else had a license.
Okay, so the owner of the vehicle, why wasn't the owner of the vehicle charged with CCW?
Since they were, I observed Mr. Eccleston reaching towards the radio, and it appeared that he was concealing some form of contraband.
And he told you it was the owner of the vehicle's gun, or he believed.
He also said it wasn't a firearm on the vehicle.
And what did she say? Did she tell you it was her gun?
She never once said it was her firearm.
Or did you interview her at all?
I'm not.
Did you ask any questions?
I talked to her about it, but no, I'm not. No, I did not.
You didn't talk to her about it?
No, I asked her about it. She stated that she, multiple people drive her vehicle. She stated a numerous amount of things, but she never one time said that it was her firearm.
Okay, but did you ask her specifically if it was her firearm?
Honestly, I might have. I talked to her for a minute. You have to watch my body cam. I'm not sure if I did or not, though.
So, just to understand, and I understand that this is an estimate, but what exactly, why was the car, why did you believe the car was able to be towed?
Because, I'm sorry, I believe the answer is that it was a part of a crime, that would be stated that he found a gun.
No further questions.
Right.
Happily clarify. Officer, you indicated the defendant has a suspended license.
Correct.
When a driver in the state of Michigan has a suspended license, are you able to tow the vehicle?
Yes.
Okay. So, you also indicated that after recovering the weapon, the vehicle was part of a crime?
Correct.
So would it be fair to say that there's two reasons that the vehicle was impounded?
Yes.
Two possible reasons?
Yes.
Okay. And I'd like to also clarify, when the defendant indicated to you that the weapon is not his and that it's the owners of the vehicle, where was the owner of the vehicle while he was saying this?
Standing right here.
Right next to him.
Correct.
At any time while he was saying that it's the owner's vehicle, or excuse me, it's the vehicle owner's weapon, at any time right next to him, did that owner of the vehicle confirm what he was saying or corroborate what he was indicated to you?
Not one time.
No further questions.
I just wanted to solve who was the weapon registered to?
I couldn't tell you. I'm not gonna read the serial number to the firearm.
I thought you said that you ran the serial though.
No, I did not.
No further questions, Joe.
None further from the people, Your Honor. Okay, Officer Gray, you're welcome. Any other witnesses for the people? No, Your Honor.
No, Your Honor.
Thank you, Your Honor. Move that defendant Anthony Eccleston be found over on count 1, weapons, firearms possession by a felon. Count 2, weapons, ammunition possession by a felon. Count 3, weapons carried concealed. Count 4, weapons, felony, firearm. Count 5, weapons, felony, firearm, and reserve for argument. Thank you, Your Honor.
Your Honor, we would object to bind over. I don't believe that the basis for the stop was appropriate. We're pulling him over for no seatbelt, and then they discovered that he does not have a license. But they're immediately going into the center console of the car, removing things with a tool that they need. And also we have my client saying that he was not the owner of the vehicle or the gun. We did have the owner of the vehicle there. I believe that if someone were to have put a gun in there, it would be more likely to be the owner of the vehicle whose gun it was, as opposed to someone just driving that vehicle. I don't believe that they've established that he was knowingly possessing a weapon, and we would ask that this case be dismissed.
Thank you. People respectfully disagree with the defense. We believe that the testimony from Officer Perry was extremely detailed when it comes to meeting probable cause standards. Officer Perry initiated a valid traffic stop, not for only one reason, but two reasons. The driver He observed the driver, the defendant, without a seatbelt on, which is a valid reason to pull over the vehicle, and also for changing lanes without using his signal, another reason. And the officer also, in detail, explained his observations of the movements that the defendant was making. He also answered that these are not movements indicative of someone turning off a radio for a moment. He actually explained that from the moment he got behind the vehicle, initiated his lights, and eventually the vehicle pulled over into the gas station, stopped, and the officer exited. In all that time, he observed the defendant still playing or do whatever, but making movements towards the area that the weapon was found. Contrary to the defendant's reasoning of picking up a phone from the floorboard. Different movements, as the officer indicated. Officer also indicated that based on several factors, the fact that the defendant was making these movements, the fact that the defendant admitted to not having a valid driver's license, and the fact that there was 4 occupants, and his belief that the defendant was making those movements in an attempt to conceal contraband or at the time of his belief a possible weapon in the area that he, in his experience, has experienced in the past that a weapon can and has been hidden in other Jeep Cherokees. He asked all the occupants out of the vehicle. He also indicated that due to the defendant appearing nervous, his answers contradicting the officer's observations, he had everybody go to the back, and he actually detained them by having each one handcuffed to the other, so that his partner could be safe while he did a wingspan search. And I believe the video actually shows, I mean, even though the defendant, or excuse me, the officer went back and forth, the officer did not do a lengthy search inside that vehicle. It actually went along with his testimony that when he finally reached in and opened up that spot, it was very quick. It didn't take very long, as we noticed in that actual video, and he pulled out the weapon. Now, I understand, it's even shown on the video, that the defendant was denying that the weapon was his. This is for a trier of fact to determine. At this point, we're at probable cause. People have met the burden of probable cause. The defendant was reaching in that area for a lengthy amount of time that under probable cause could show that he was putting something there. The weapon is found there. On top of that, he is a felon. We've shown that his conviction precludes him from actually at any time having possession of a weapon or ammunition. Therefore, we believe that count 1, 2, 3, 4, and 5 have been met, and as indicated, he does not have a CPL because obviously a felon cannot obtain a CPL, but he did also admit to that. Everything else, I understand that that's for a question of fact for a trier of fact. So we ask that he be found over on all charges. Thank you.
And any evidence that may seem Attorney Hamilton and whoever, I believe the valid stop based off of and failure to signal as well as not wearing seatbelt. Those are stoppable offenses, as Officer Perry did stop the defendant, and once he stopped the defendant, asked the defendant what he was buying, and then proceeded to ask whether or not the defendant had a license. The defendant said no, and that did trigger officer's ability, and he used the discretion to further investigate his ability to tow the vehicle. While initiating the stop of the defendant, Officer Perry stated and testified that he saw the defendant reaching for approximately 30 seconds around what he described as the final control box in the Jeep Cherokee, which is under the radio. and he believed that there could be some contraband or something or a gun in that compartment. As the defendant and the other arguments, there's three other arguments out of the vehicle for officer safety and to investigate what he believed the defendant was hiding. And as you can see on the video, within 5 seconds, he found the gun right where he reached, or right in the area where he described that the defendant reached, and was moving around for 30 seconds. I do believe that people have met his burden of proof today. I believe there was possession in this case. There was knowledge by the defendant as well as the defendant's ability to control that weapon while he was driving. Plus, there's a question about CPLs for everyone else. State law requires that the individual must provide a CPL when a gun is present, especially in this case, and we carry a concealed weapon, and no one provided a CPL during the stop. And also the defendant admitted that he did not have a CPL. So I believe that is enough at the probable cause standard to satisfy count 3, which would be weapons carried concealed, with all of the accompanying accounts here, because Mr. Eggleston is a felon. So count 1 is satisfied with exhibit 1, as well as count 2, as there's testimony that the gun was loaded, and then of course count 4 as the accompanying fire. So Mr. Eggleston, you'll be bonded over to 3rd Circuit Court, Frank Murphy Hall of Justice, for your arraignment on the information. It'll be 2 weeks from today. It'll be June 27th at 9:00 a.m. And bond is
Person?
So every judge is different. I've tried to get clarification. You'll have to talk to
It's I just don't understand that Zoom stuff. That's how I had a problem last time.
It depends on the judge, and I don't know who the judge is yet, so. You have to ask your attorney. Thank you. But it will be a night.
Okay.
Anything else from the party?
No. Thank you.
Very much, Henry.
Attorney Upshaw, you can come on up.
Yes, Your Honor, thank you.
Are there witnesses here on?
Howard.
Thank you. How?
Yes.
Okay. Are you aware of this?
Yes.
All right. You want to bring the witnesses in? We have a date of 30th.
That's 30th?
Yeah, it's 9:00.
Yes. That's a good date for them.
I'm saying no. Shannon. We're on the record. This is case 230569781, people of the state of Michigan versus Teresa Sade Yariel Howe. Ms. Howe is charged with count 1, count 2, assault with a dangerous weapon. And so count 4 and 5, weapons starting firearm, set for the exam. Yes.
Alexander Kirker on behalf of the people, P86282.
And Randall Upshaw on behalf of Ms. Howell, number 435, so what's the name reference?
Good morning. Does everybody understand that Attorney Upshaw, you were just retained yesterday?
Last night. Okay.
All right, so you're requesting an adjournment, correct?
Yes, I
So we have June 30th at 9 o'clock as the date that we're going to start.
Should work for the people, Your Honor. I will go speak with the witnesses.
works with the judge.
Do you want me to wait? Please speak with witnesses?
I can go quickly.
Okay.
30th at what time?
9 o'clock. How are you doing?
Till 1:30.
That date does work.
Okay, all right. June 30th at 9 o'clock.
Judge, is always a pleasure. You have a good day.
Thank you. And we're back on the record on Ms. Larissa Howe. To address Kevin.
Yes, Your Honor. You have Ms. Howell. I know I looked at the case and I've had a chance to look at some papers. She has absolutely no prior record. I understand that the victims are neighbors, and she has a hospital. She's under doctor's treatment right now. What test are you having?
48-hour
EEKG.
Okay.
And as stated, not make light of no gunshot was fired here, no one was injured, no one shot, no discharges. What's alleged is that someone, her daughter and the young man down the street had a problem, so his parents tried to resolve it. And from the police report, they said she was armed with this pistol, even though It never says she attempted to shoot anyone. No one does attempt to be shot. And it's questionable whether she had a point. What I'm asking, Judge, would you consider, one, for medical purposes, and two, for the facts and the lack of a record at all, to consider removing the tether on that?
Ms. Howell, question, so for the EKG, what's the issue?
I can have any metal on me, like any jewelry, anything, because it channels the waves in my brain. And then I also have an upcoming, this will be my fourth MRI. And then I see a cardiologist as well to get my heart checked. So
Okay, we are on the record. This is people of the state of Michigan versus Michael Thomas O'Neill. 2357042. Mr. O'Neill is charged with count one, assault with intent to murder. Count two, weapons of firearm. Count three, assault with intent to do great bodily harm less than murder or by simulation. Count four, weapons of firearm. Count five, assault with a dangerous weapon, felonious assault. Count six, weapons of firearm. Count seven, assault with intent to murder. Count eight, weapons of firearm. Count nine, assault with intent to do great bodily harm less than murder or by strangulation. Count 10, weapons of firearm. Count 11, assault with dangerous weapon, felonious assault. Count 12, weapons of firearm. Count 13, weapons, firearms, possession by felon. Count 14, weapons, firearm. Count 15, weapons, ammunition, possession by felon. Count 16, weapons, firearm. With an habitual offender's second offense notice set for example. Appearances.
Good morning, Your Honor. Daniela Parrish on behalf of the people, P85495.
And good morning, Your Honor. Nicole James, appearing on behalf of Mr. O'Neill. My P number is 58961.
And Mr. O'Neill, please state your full name for the record, please.
Michael Thomas O'Neill.
Okay. And what's going on with this case, Mr. Parrish?
Your Honor, my apologies. People are unable to proceed today with the exam. Two necessary complaining witnesses on the case have failed to appear. I do have the stand-in OIC. When I say stand-in, he's standing in for the actual OIC, Ryan Paul. Officer Sharp, if you wouldn't mind, if you could go on the record to indicate the fact that the complaining witnesses were aware of today's exam. Please.
Could you can stand right here and speak loudly so that the court reporter can hear you.
Morning, Your Honor.
Good morning.
Should we indicate the name?
Officer Ryan Sharp, I'm the precinct director.
Okay, and you've had contact with complaining witnesses?
I spoke with officer in charge who stated that he spoke with the victims over the phone who refused to show up to the court date.
Okay. They were made aware and subpoenaed?
Correct.
Okay.
Your Honor,
Attorney James?
the people not being able to proceed, we would ask this case be dismissed.
Hey, I will dismiss without prejudice as complaining witnesses do not wish to prosecute and are not present today.
Thank you, Your Honor.
You're all set, Mr. O'Neill. Your case has been submitted.
How about you?
We're back on schedule. Wow.
Okay, I'll be outside.
Yeah, yeah. Okay. We're on the record, this is the people of the state of Michigan versus Terrence Devon Brown, case 2355954. Mr. Brown is charged with one count of stolen property, receiving and concealing a motor vehicle with an habitual offender. Second offense notice set for an exam today. Appearances.
Alexander Kirker on behalf of the people, P 86282.
Good morning, Your Honor. Good morning to your staff. Ted Wallace, P80922 on behalf of Mr. Brown, who stands to my right. Mr. Brown, please state your name for the record.
My name is Terrence Devon Brown.
Good morning.
Good morning.
Okay, I have before me a waiver form. Is it correct, Attorney Wallace, that your client is waiving his exam today?
It is, Your Honor. I've discussed the fact that Mr. Brown does have a statutory right to a preliminary exam and that the people would be required to prove that there was probable cause that a crime had been committed and that he was the one that committed it. And after talking to him, it's his wish to waive the preliminary exam and having it found out to the Third Circuit Court.
Is that correct, Mr. Brown?
Yes, ma'am.
Did anyone force you or threaten you to waive your exam? Did anyone promise you anything? Any objection from the people?
No objection, Your Honor.
Okay, Mr. Brown, I find your waiver to be freely, understandingly, and voluntarily given. I'm gonna be bound over to Third Circuit Court, Framework Hall of Justice, for the ring on the information date of June 27th at 9:05 a.m. It's my understanding that every judge is different, so I can't tell you whether it's on Zoom or in person.
I'm good.
Nor do I know the judges.
I'll keep them abreast of what's going on. Thank you.
Okay. Anything else from you, Department?
Nothing.
No, you're welcome.
Okay, you're all set, Mr. Brown.